Huh?
He got his attention.
The kid's the darndest things. Looks like he's ready to sleep.
That's what you think. Okay. Back to this mess.
You seriously just took a break?
Yeah, that was my break.
So how long are we gonna go?
Until I'm done. It will be no more than 45 minutes. In fact, it should be significantly less. I just got to the section of damages. I think that's the title of Module 8. And as it relates to common law. So the first part that we're going to go into is the contracts for sale of land. The standard measure of damages for breach of land sale contracts is the difference between the contract price and the fair market value of the land. Next, employment contracts. And employment contracts check to see whether the breach was by the employer or the employee. If it's by the employer, irrespective of when the breach occurs, before performance, after part performance, or after full performance, the standard measure of the employee's damage is the full contract price, although such damages may be reduced if the employee fails to mitigate. Breach by employee. If an employee materially breaches an employment contract, the employer is entitled to recover the cost of replacing the employee, that is, the wages the employer must pay a replacement employee minus the breaching employee's wages. The breaching employee may offset money owed for work done to date. Part C under employment contracts is employment at will. When employment is at will, it may be terminated at any time for any reason. Thus, termination of an at-will employment by either party does not result in a breach. A position characterized as permanent creates an employment at will relationship. And next, construction contracts. If a construction contract is breached by the owner, the builder will be entitled to profits that would have resulted from the contract, plus any costs expended. The contract is breached after construction is completed. The measure is the full contract price plus interest. If the contract is breached by the builder, the owner is entitled to the cost of completion plus reasonable compensation for the delay. Most courts allow the builder to offset or recover for work performed to date to avoid unjust enrichment of the owner and the breach. In the breach, if the breach is only late performance, the owner is entitled to damages incurred because of the late performance. Restoration and economic waste. Usually, when a builder contract is not properly performed, the owner is entitled to the cost of fixing the defect. However, unless there is a special significance attached to the use of a particular item, for example, the owner is the CEO of a particular brand of copper pipe specified, and that significance is communicated to the builder, a court will not order a remedy that results in undue economic waste. Courts are split on the result when a party contracts to restore property and willfully refuses to do so because it is much more costly than diminution in value of property. Contracts calling for installment payments. If a contract calls for payments and installments and a payment is not made, there is only a partial breach. The aggrieved party is limited to recovering only the missed payment, not the entire contract price. However, the contract may include an acceleration clause making the entire amount due on the late payment, in which case the aggrieved party may recover the entire amount. Avoidable damages mitigation. Under the common law, the non-breaching party cannot recover damages that would or could have been avoided with reasonable effort. Thus, they must refrain from piling up losses after they receive notice of the breach. They must not incur further expenditures or costs, and they must make reasonable efforts to cut down their losses by procuring a substitute performance at a fair price. Should they not do so, they will not be allowed to recover those damages that might have been avoided by such mitigation after the breach. Generally, a party may recover the expenses of mitigation. Note the following specific contract situations: employment contracts, manufacturing contracts, construction contracts, contracts for sale of goods. And that all comes within this section. Again, this section is avoidable damages, so mitigation of damages. So here's the specific circumstances. If the breaching employer can prove that a comparable job in the same locale was available, then contract damages against the breaching employer for lost wages will be reduced by the wages that the plaintiff would have received from that comparable job. Manufacturing contracts, generally in a contract to manufacture goods. If the person for whom the goods are being manufactured breaches, the manufacturer is under duty to mitigate by not continuing work after the breach. However, if the facts are such that completion of the manufacturing project will decrease rather than increase damages, the manufacturer has a right to continue. Construction contracts. A builder does not owe a duty to avoid the consequences of an owner's breach by securing other work, for example, but does have the duty to mitigate by not continuing work after the breach. Again, however, if completion will decrease damages, it will be allowed. And lastly, contracts for sale of goods under Article 2. The rule of mitigation generally does not apply. An injured buyer is not required to cover, and an injured seller is not required to resell. Market damages are always available if the buyer does not cover for the seller or the seller does not resell. Recall, however, that the seller generally cannot bring an action against the buyer for the full contract price unless the goods cannot be resold at a reasonable price or were damaged or lost when the risk of loss was on the buyer. Restitution. As an alternative to the contract damages discussed above, restitution may be available in a contract type situation. Restitution is not really part of contract law, but rather it is a distinct concept. Restitution is based on preventing unjust enrichment when one has conferred a benefit on another without gratuitous intent. Restitution can provide a remedy not only when a contract exists and has been breached, but also when a contract is unenforceable. And in some cases when no contractual relationships exist at all between the parties. Terminology. When a contract is unenforceable or no contract between the parties exists, an action to recover restitutionary damages often is referred to as an action for an implied in-law contract, an action in quasi-contract, or an action for quantum merit. Measure of damages. Generally, the measure of restitution is the value of benefit conferred, although this is usually based on the benefit received by the defendant. For example, the increase in value of the defendant's property or the value of the detriment suffered by the plaintiff. For example, the reasonable value of the work performed or the services rendered. If benefits are difficult to measure or the benefit measure would achieve an unfair result. Specific applications. When a contract has been breached and the non-breaching party hasn't fully performed, they may choose to cancel the contract and sue for restitution to prevent unjust enrichment. Note that if the plaintiff has fully performed, they are limited to their damages under the contract. This may be less than they would have received in restitutionary action because the restitutionary remedy isn't limited to the contract. Losing contracts. A restitutionary remedy often is desirable in the case of a losing contract, a contract in which the actual value of the services or goods to be provided under the contract is higher than the contract price because normal contract expectation damages or reliance damages would be for a lesser amount. Breach by plaintiff. Under some circumstances, the plaintiff may seek restitution even though the plaintiff is the party who breached. If the breach was intentional, some courts won't grant the breaching party restitution. Modern courts, however, will permit restitution recovery but limit it to contract price less damages incurred as a result of the breach. Restitution of advance payments or deposit if buyer of goods breaches. So, restitution isn't part of law, of contract law, but rather a distinct concept. Restitution is based on preventing unjust enrichment where one has conferred a benefit on another without gratuitous intent. So, again, I just want to remind myself of the definition before going into this: restitution of advance payments or deposit if buyer of goods breaches. The buyer has paid part of the purchase price in advance and then breaches the contract. They can usually recover some of the payments. Unless the seller can prove greater damages, they may keep advance payments totaling 20% of the purchase price or $500, whichever is less. The balance must be returned to the buyer. If there is a valid liquidated damages clause, the seller need refund only the excess of the buyer's payment over the amount of liquidated damages. Oh my gosh, when contracts unenforceable quasi-contract remedy, and then we will soon go into rescission and reformation, and including many times use of the word misrepresentation and mistake. So again, when a contract is unenforceable and you have a quasi-contract remedy, the restitution may be available in a quasi-contract action when a contract was made but is unenforceable and unjust enrichment otherwise would result. For example, a celebrity is hired to sign autographs and is paid but dies before they perform. The other party has a restitutionary action to recover the payment. When no contract involved quasi-contract remedy, restitution may also be available in a quasi-contract action when there is no contractual relationship between the parties. If the plaintiff has conferred a benefit on the defendant by rendering services or expending properties, the plaintiff has conferred a benefit with a reasonable expectation of being compensated for its value. The defendant knew or had reason to know of the plaintiff's expectation, and the defendant would be unjustly enriched if they were allowed to retain the benefit without compensating the plaintiff. Rescission. Rescission is the remedy whereby the original contract is considered voidable and rescinded. The parties are left as though a contract had never been made. The grounds for rescission must have occurred either before or at the time the contract was formed. The grounds for rescission are mutual mistake of material fact, unilateral mistake if the other party knew or should have known of the mistake, unilateral mistake if hardship by the mistaken party is so extreme it outweighs the other party's expectations under the contract, misrepresentation of fact or law by either party as to a material factor in the negotiations that was relied upon, and other grounds such as duress, undue influence, illegality, lack of capacity, and failure of consideration. Defenses. Generally, all equitable defenses, including laches and unclean hands, are available in a rescission action. Note that the plaintiff's negligence is not a defense. Additional relief. If the plaintiff has paid money to the defendant, they are entitled to restitution in addition to rescission. Reformation. Reformation is a remedy whereby the writing setting forth the agreement between the parties is changed so that it conforms to the original intent of the parties. Grounds. Mistake. To reform a contract because of mistake, there must be 1, an agreement between the parties, 2, an agreement to put the agreement in writing, and 3, a variance between the original agreement and the writing. So, what's the difference between rescission and reformation? Rescission is a remedy whereby the original contract is considered voidable and rescinded. The parties are left as though no contract was made. And whereas reformation is a remedy whereby the writing setting forth the agreement between the parties changed so that it conforms to the original intent of the parties. Grounds for reformation include mistake. I just read this. An agreement between the parties. The agreement put in 2, put the agreement in writing, and 3, a variance between the original agreement and the writing. With misrepresentation, if a writing is inaccurate because of a misrepresentation, the plaintiff can choose between reformation and avoidance. To qualify for reformation, the misrepresentation must relate to the content or the legal effect of the record. Misrepresentation as to the subject nature of the agreement aren't grounds for reformation, rescission, and damages are the proper remedy for that. Negligence does not bar reformation. Failure to read the record of the agreement doesn't preclude a party from obtaining reformation. In nearly every case in which the record doesn't reflect an agreement, either one or both parties have failed to read it. Clear and convincing evidence standard. The variance between the antecedent agreement and the writing must be established by clear and convincing evidence. Next, parole evidence rule and statute of frauds do not apply. The parole evidence rule isn't applied in reformation actions. Likewise, the majority rule is that the statute of fraud does not apply, but many courts will deny reformation if it would add land to a contract without complying with the statute of frauds. Defenses. In addition to the general equitable defenses, the existence of a bona fide purchaser for value is also a defense to reformation. Similarly, reformation isn't permitted if the rights of third parties will be unfairly affected. Statute of limitations under UCC. For sales contracts, the UCC provides for a 4-year statute of limitations. The parties may shorten the period by agreement to no less than 1 year, but they can't lengthen it. Accrual of action. The statutory period begins to run when a party can bring suit, that is, when breach occurs. The period begins to run regardless of whether the aggrieved party knows about the breach. Breach of warranty actions. For a breach of warranty action, the breach occurs and the limitations period begins to run upon delivery of the goods. This is true even if the buyer doesn't discover the breach until much later. Warranty extends to future performance. If there is an express warranty that explicitly extends to the future performance of the goods, the 4-year period doesn't begin to run until the buyer should have discovered the breach. And implied warranties breached on delivery. Because implied warranties cannot explicitly extend to future performance, they are breached, if at all, upon delivery. So we got to Module 9. The rights and duties of third parties of the contract. Non-parties to a contract may have rights or duties in connection with the contract. Power of person other than owner to transfer a good title to a purchaser. Entrusting goods to a merchant who deals in goods of that kind gives them the power but not the right to transfer all the rights of the entrustor to a buyer in the ordinary course of business. Entrusting includes both delivering goods to the merchant and leaving purchased goods with the merchant for later pickup or delivery. Buying in the ordinary course means buying in good faith from a person who deals with goods of the kind without knowledge that the sale is in violation of the ownership rights of third parties. Voidable title concept. Generally, if a sale is induced by fraud, the seller can rescind the sale and recover the goods from the fraudulent buyer, meaning it is a voidable title. However, the defrauded seller may not recover the goods from a good faith purchaser for value who bought from the fraudulent buyer. The rights of a defrauded seller are cut off both by the good faith buyer and by a person who takes a security interest in the goods. 9.1.3, thief generally cannot pass title. If a thief steals goods from the true owner and then sells them to the buyer, the thief is unable to pass title to the buyer because their title is void. Rationale, a seller can transfer only the title they have or have power to transfer. Therefore, even a good faith purchaser for value generally cannot cut off the rights of the true owner if the seller's title was void. An exception to this rule may apply, however, if the buyer has made accessions, valuable improvements to the goods, or the true owner is stopped from asserting title. For example, the true owner expressly or impliedly represented that the thief had title. Third-party beneficiaries. In the typical third-party beneficiary situation, A, the promisee contracts with B, the promisor, that B will render some performance to C, the third-party beneficiary. Who is third-party beneficiary? Intended versus incidental beneficiary. Only intended beneficiaries have contractual rights, not incidental beneficiaries. In determining if the beneficiary is intended, consider whether the beneficiary, 1, is identified in the contract, 2, receives performance directly from the promisor, or 3, has some relationship with the promisee to indicate intent to benefit. So, identified, receives performance directly, and relationship with the promisee to indicate intent to benefit. Creditor versus donee beneficiary. There are two types of intended beneficiaries. One, the creditor beneficiary, a person to whom the debt is owed by the promisee, and two, a donee beneficiary, a person whom the promisee intends to benefit gratuitously. What are the rights of the third-party beneficiary and the promisee? Third-party beneficiary versus promisor. A beneficiary may sue the promisor on the contract. The promisor may raise against the third-party beneficiary any defense that the promisor has against the promisee. Whether the promisor may use the defenses the promisee would have against the third-party beneficiary depends on whether the promisor made an absolute promise to pay or only a promise to pay what the promisee owes the beneficiary. If the promise is absolute, the promisor cannot assert the promisee's defenses. If the promise is not absolute, the promisor can assert the promisee's defenses. Third-party beneficiary versus promisee. A creditor beneficiary can sue the promisee on the existing obligation between them. They may also sue the promisor, but may obtain only one satisfaction. A donee beneficiary has no right to sue the promisee unless grounds for a detrimental reliance remedy exist. And promisee versus promisor. The promisee may sue the promisor both at law and in equity for specific performance if the promisor isn't performing for the third person. Determining intended third-party beneficiary status and contractual rights. At the time the contract was made, did the promisor promise the promisee to render some performance to a third party? If no, this is not a third-party beneficiary situation. If yes, proceed in the next question in the decision tree. If the third party specifically identified in the contract, 2, to receive performance directly from the promisor, or 3, in some relationship with the promisee to indicate intent to benefit. If no, the third party cannot enforce the contract. If yes, proceed to the next question. Have the third party's rights vested in third parties? 1, assenting to the contract. 2, bringing suit to enforce the contract. Or 3, materially changing position and justifiable reliance to the promise. If no, the promisor and promisee are free to change the contract terms, including changing the beneficiary. If the answer is yes, however, the third party can enforce the contract against the promisor, subject to the promisor's defenses against the promisee, unless the promisor made the absolute promise to perform. Okay, now we're on page 144 here. When do the rights of the beneficiary vest? This is a 2-paragraph section. A third party can enforce a contract only if the rights have vested. This occurs when they 1, manifest assent to a promise in the manner requested by the parties, 2, bring a suit to enforce the promise, or 3, materially change position and justifiable reliance on the promise. Prior to vesting, the promisee and promisor are free to modify or rescind the beneficiary's rights under the contract. A, significance of vesting. Before the intended third-party beneficiary's rights vest, the promisor and promisee are free to modify their contract, including removing the third-party beneficiary altogether, without consulting the third party. Once the third party's rights vest, the promisor and promisee cannot vary his rights without his consent. Now you have assignment, a new section titled Assignment of Rights and Delegation of Duties. So we talk about assignment first. This will be about 5 pages before getting to delegation. And then we'll get to novation after that. Delegation is much shorter. I'm actually inclined to read delegation first and novation because they're so short. They're only like 3 more pages after we get through these first 5. But let's just start with assignment as is so intended, probably for a reason. Assignment rights and delegation of duties. Assignment. In the typical assignment situation, X, the obligor, contracts with Y, the assignor. Y assigns his right to X's performance to Z, the assignee. What rights may be assigned? Generally, all contractual rights may be assigned. Exceptions. 1, an assignment that would substantially change the obligor's duty of risk. For example, personal service contracts where obligor's duty where the service is unique, and 2, the assignment of future rights to arise from future contracts, not future rights in already existing contracts, and 3, the assignment prohibited by law, including wage assignments in some states. B, effective assignment. The effect of an assignment is to establish privity of contract between the obligor and the assignee while extinguishing privity between the obligor and the assignor. Once the obligor has knowledge of the assignment, they must render performance to or pay the assignee. If the obligor renders performance to or pays the assignor, they do so at their own risk. Typically, one of the parties, usually the assignee, will notify the obligor of the assignment. C, what is necessary for an effective assignment? For an assignment to be effective, the assignor must manifest an intent to immediately and completely transfer their rights. A writing is usually not required to have an effective assignment. The right being assigned must be adequately described. It is not necessary to use the word assign. Any accepted words or transfer will suffice. A gratuitous assignment is effective. Consideration is not required. D, is assignment revocable or irrevocable? Assignments are divided into 2 categories: assignments for value and gratuitous assignments. Assignment for value. An assignment for value is 1, done for consideration, or 2, taken as security for or payment of a pre-existing debt. Assignments for value cannot be revoked. Gratuitous assignments. An assignment not for value, a gratuitous assignment, generally is revocable. Exceptions to revocability. A gratuitous assignment is irrevocable if 1, the obligor has already performed, 2, a token shows that is a tangible claim such as a stock certificate is delivered, 3, an assignment of a simple chose that is an intangible claim such as a contract right is put in writing, and 4, the assignee can show detrimental reliance on the gratuitous assignment, that is a stop. Methods of revocation. A revocable gratuitous assignment may be terminated by 1, the death or bankruptcy of the assigner, 2, notice of revocation by the assigner to the assignee or the obligor, 3, the assigner taking performance directly from the obligor, or 4, subsequent assignment of the same right by the assigner to another. Effective revocation. Once an assignment is revoked, the privity between the assigner and the obligor is restored, and the assigner is once again the real property and interest. Express contractual provision against assignment. A clause prohibiting assignment of the contract will be construed as barring only delegation of the assigner's duties. A clause prohibiting assignment of contractual rights generally doesn't bar assignment, but rather merely gives the obligor the right to sue for damages. However, if the contract provides that attempts to assign will be void, the parties can bar assignment. Also, if the assignee has notice of the non-assignment clause, the assignment will be ineffective. F, what are the rights and liabilities of the various parties? Assignee versus obligor. The assignee can sue the obligor as the assignee is the real property and interest because it is the assignee, not the obligor, is entitled to performance under the contract. The obligor has a defense against the assignee that any defense inherent in the contract, for example, failure of consideration and other defenses that came into existence before the obligor had knowledge of the assignment. The obligor cannot raise by way of defense any defenses the assignor might have against the assignee. Assignee versus assignor. In every assignment for value, the assignor warns that 1, they have not made a prior assignment of the same right, 2, the right exists and is not subject to any undisclosed defenses, And 3, they won't interfere with the assigned right. The assignee may sue the assignor for breach of any of these warranties. However, the assignor won't be liable to the assignee if the obligor is incapable of performing. That's the assignee versus the assignor for in assignments for value. The warrant from the assignor is 1, they have not made a prior assignment of the same right. 2, the right exists and is not subject to undisclosed offenses. 3, they won't interfere with an assigned right. And the assignee may sue the assignor for breach of any of these warranties. However, the assignor won't be liable to the assignee if the obligor is capable of performing. Okay. Multiple assignments, which assignee gets to collect. This is the last section in assignment before delegation. If the first assignment is revocable, a subsequent assignment revokes it. Assignment revokes it. If it is irrevocable, the first assignment will usually prevail over a subsequent assignment. Several expectations exist if the second assignee has paid value and taken without notice of the first assignment. 1, the subsequent assignee gets the first judgment against the obligor. 2, the subsequent assignee gets the first payment of a claim from the obligor. 3, the subsequent assignee gets delivery of a token chose. 4, the subsequent assignee is a party to a novation releasing the assignor. Or 5, the subsequent assignee can proceed against the first assignee on an estoppel theory. Estoppel could, of course, operate against the subsequent assignee as well. Delegation. In a typical delegation situation, the obligor delegator promises to perform for X, the obligee. Y delegates their duty to Z, the delegate. What duties may be delegated? Generally, all duties may be delegated. Exceptions: 1, duties involving personal judgment and skill. Delegation. 2, delegation would change the obligor's expectancy. For example, requirements in output contracts. 3, the special trust was reposed in the delegator by the other party to the contract. And 4, there is a contractual restriction on delegation. B, what is necessary for effective delegation? The delegator must manifest a present intention to make a delegation. There are no special formalities to be complied with to have a valid delegation. It may be written or oral. Now, C, what are the rights and liabilities of the parties? The obligee must accept performance from the delegate of all duties that may be delegated. The delegator remains liable on the contract. Thus, the obligee may sue the delegator for non-performance by the delegate. The obligee may require the delegate to perform only if there has been an assumption, that is, the delegate expressly or impliedly promises that they will perform the duty delegated, and this promise supported by consideration or its equivalent. This promise creates a contract between the delegator and the delegate in which the obligee is a third-party beneficiary. Terminology. Today, we're designing the contract, or all my rights under the contract are usually construed as including an assumption of the duties by the assignee unless a contrary intention appears. Lastly, novation. Distinguished. Novation substitutes a new party for an original party. To the contract, it requires assent of all parties and completely releases the original parties. So we're on page 151, and that's the end of CMR for contracts.